Good afternoon, everyone, and a warm welcome to today's webinar. My name is Edgars Riņķis, and I'm a senior associate here at Sorainen, Latvia, and I will be your moderator for this session. And today we are focusing on the most significant and fast approaching regulatory changes affecting the employers right now, which is the Pay Transparency Directive. And with the implementation date set for June 7th of this year, we have seen that clients and businesses are increasingly seeking of what the new framework will require. And so our goal today is to provide a clear overview of where each Baltic jurisdiction stands and what the employers should be preparing for. And today we are joined by my colleagues from across the Sorainen team, who will guide you through the latest developments in their respective countries. My colleague from Lithuania, Agnietė Venckienė, Counsel at Sorainen, Lithuania. She will provide information through the Lithuania's fourth draft. And my colleague, Associate Karl Oskar Pungas from Estonia, who will walk us through the situation in Estonia. And then after that, I myself will provide a brief update for Latvia and where we are right now and where we might be headed. And after the presentations, we will open up the floor for a dedicated Q&A session. But also feel free to ask questions in the Q&A section. And if you want to, you can upvote the questions that seem most interesting to you, and we will know which ones to prioritize after our presentations. So yeah, thank you all for joining us, and let's begin with a brief overview of the directive. I'm sure you all are well aware of what the directive brings, but to remind that this directive sets requirements for pay transparency, and the idea is to strengthen the principle of equal pay for men and women if they perform work of equal value or equal work. And of course, this also comes with the objective of preventing discrimination and also making sure that the employees have tools to protect their rights. The obligations of the directive can be kind of compartmentalized into two blocks, I would say. One is, of course, the job and payment evaluation itself, which means that the employers have to gather data, assess what are the job obligations the employees are doing, identify which remuneration components are in the company. And this also comes with the categorization and determining the value of work of employees based on the criteria provided by the directive: skills, effort, responsibility, and working conditions. And also the employers have to determine the salary levels, which means figuring out those pay bands and the individual salaries within those pay bands, and most importantly, in terms of risk, identifying any outliers in the sense of pay, especially the ones who are underpaid, because this is where most of the risks come from. And the other portion of the obligations is the informing portion, and the employees have to be informed about the payment pre-employment, which means information provided in the job ads or before the employment commences. Also, information about about the criteria which are used to determine pay levels and how pay progression is also set. And for this, the directive allows for an exemption if there are less than 50 employees, meaning that if you employ less than 50 employees, you might not have the obligation to inform employees about the criteria. And also the employees have to be informed about their salary levels in the category of work which they are in, meaning that employees have to be informed about the individual pay level and the average pay level broken down by sex. And also each year, the employers have to remind the employees about their rights to this information. And not only the employees have to be informed, but also the state, which is where the pay gap reporting obligation comes into. And there is also an exemption for employees who employ less than 100 people, so which the national legislators may invoke. And for the next slide, regarding the implementation progress in Baltics, we see that the Lithuanians are a bit more diligent in their duties, and well, the northern neighbors are lagging behind here. As Estonia and Latvia, we don't have even the first draft, even though the implementation date is still June 7th. And so, without further ado, let's get into the Lithuanian portion. And my colleague Agnietė Venckienė, Counsel of Sorainen, Lithuania, and co-head of the employment practice. Agnietė, the floor is yours.
Thank you, Edgars, for introducing me. So hello, everyone, and thank you for joining us this afternoon. As Edgars mentioned, my name is Agnietė, and I'm working in Lithuanian employment team at Sorainen. And yes, it is true, Lithuania is very diligent with implementing employment-related EU directives. So pay transparency is not an exception, and we are on track to have the directive implemented by the set deadline in June 2026. Yeah, the current status in Lithuania is that we have already the 4th version of the amendments to the labor code registered in the beginning of March. So the government is well on track to have the law implementing the directive passed on time, to have it ready by 7th of June 2026 to be fully enforced. We have been in pretty much constant communication with the State Labor Inspectorate and the Ministry of Social Security and Labor, who are working on implementing the directive, and they have been working on this for the past couple of years. So there is no surprise that we are very, very close to full implementation. Lithuania already had some regulations in our labor code addressing pay transparency. So maybe we had some less preparation to do compared to our neighbor Baltic countries, but still the final laws implementing the directive have not been passed yet. So we have the 4th version of the draft, and considering that the latest changes have been rather technical, I am, let's say, cautiously optimistic that the final law that will be adopted by the Parliament, hopefully in late spring of this year, will be very close to what we have now. As I mentioned, the government is very much motivated to have the laws passed, and the effective date will be 7th of June 2026, unless something dramatic happens and the plan collapses. Unfortunately, we still don't have the secondary laws or draft laws published for public review yet, and these address very important topics on the mechanics of pay reporting and maybe less urgent, the joint pay assessment. And what worries employers the most is the pay reporting, because as you will see, this is something that they will have to do every month, starting with June or July of this year. So there is very little time to prepare for that. So I will start with some sections describing the main areas of the directive and how it is implemented in Lithuania, or it's going to be implemented in Lithuania based on the current draft law. So the first part, of course, is job categorization. I believe it is the most crucial and important part in preparing employers preparing to implement the directive and in their organizations, because a bad job categorization will lead to bad reporting and consequently poor outcomes in this result. So we are stressing to our clients to be very diligent here. So in terms of job categorization, Lithuania has not removed too much from the directive. It is quite straightforward. So all employers, regardless of the headcount, will have to categorize employee positions to separate groups or categories based on the value of the job. And this categorization must be based on objective and gender-neutral criteria. No surprises here. The Lithuanian Labor Code provides some mandatory criteria that will have to be included in this categorization, which includes both hard and soft skills. And the draft law has stressed soft skills quite significantly and provided even some more detailed explanation there, what employers should take into account. Also qualifications necessary for the job, effort, responsibility, and working conditions. And the law is very clear that the jobs of equal value must be grouped to the same category, meaning that reporting of pay information for these jobs will be also done together. The next one is the pay system, or how we call it in Lithuania, remuneration policy, which is maybe a bit more clumsy to pronounce for me, so I will try to keep with the pay system. So in Lithuania, we had a legal requirement to have a written pay system or policy for companies with 20 plus employees for quite many years already. I believe it's going to be 9 years this summer. So most employers have or should have this policy. However, with the directive and the pending amendments in law, more strict requirements to the pay system will apply in terms of the content and job categorization and the employers to whom this will become mandatory. So as of June of this year, the pay system will be required not only for employers with 20 plus employees, but for all employers, even those who have 2, 3, even 1 employee besides the managing director. So in my opinion, considering that the pay system in Lithuania must be made in writing and it must contain quite a detailed information on employee pay, it may be quite high administrative burden for small employers with very, very few employees, but still they will have to comply with this. And the pay system will have to be made, as I mentioned, in writing as a document and made available to all employees, whether in the company's intranet, shared by email, HR online system, HR office, whatever way it is convenient for the company, but all employees should be able to access the pay system and read through it as frequently as they want to. And before amending or adopting the pay system, employers will have to carry out information and consultation procedure with employee representatives. So unlike my neighboring countries, Latvia and Estonia, in Lithuania, companies with 20 plus employees have an obligation to organize election to the Works Council as a company level employee representative body. So most larger employers already have this employee representation, and the Works Councils will have to be included in this information and consultation. However, it does not mean that employers will have to obtain the Works Council's consent to the pay system, or that the Works Council may veto the pay system proposed by the employer. They don't have this right according to Lithuanian law. So this is more for collaboration, hearing out employee opinion, proposal, and so on. But the final decision will lie with the employer as previously. Now for the content requirements. So the Lithuanian Labor Code does have some strict requirements for what must be reflected in this pay system. So each pay system will have to list the job categories that we talked about a few slides ago, the form of remuneration or pay for each job category or job. So for example, whether it's only fixed salary or it's fixed salary plus variable pay or only variable salary, depending on the situation on the ground. The law also already has for a number of years a requirement to disclose base salary amounts or salary ranges in this pay system. So this requirement remains. And the law will require to be more transparent and precise about the terms of variable pay, for example, bonuses, whether they are annual, quarterly, monthly bonuses, commission, and so on. If they are not ad hoc, fully discretionary bonuses, they will have to be described in the pay system with the clear terms, payment timing, eligibility criteria, if not specific amounts, then the main principles, how the bonuses will be calculated, and so on. So many employers will have to do some work on this. The law also requires to mention wage indexation at the pay policy, but it is very rarely done in Lithuania. So this rule does not really work in practice. And some new requirements coming with the directive is the pay policy having to include information on salary progression terms. So how often salaries will be reviewed and how the salary increases will be decided, what criteria will be used, and so on. So this is also something that employers are working on and some are a bit concerned about. The next topic is providing pay information, and in Lithuania we have it seems that we will have a complicated network on how and to whom and when and how often this information will have to be provided. So I will do my best to make this clear because it is actually quite complicated. So the pay information will have to be provided first to Social Insurance Authority. Lithuanians will know that in Lithuania it's called Sodra, then to the employees directly and to employee representatives, which in most cases are works councils, but sometimes maybe also trade unions. So the first part, it's pay reporting to Social Insurance Authority. So it seems that in Lithuania, how the government has decided to implement the reporting part of the directive is doing the pay reporting through the Social Insurance Authority, the same channel that is used for monthly payroll reporting in terms of social security contributions that all employers do every month anyway. So the pay information, much more detailed than now, definitely, but it will be provided by employers using the same system. And pay reporting in terms of the directive will have to be done by all employers, regardless of the headcount. And this will have to be done every month. So if nothing changes, then the first reporting will have to be done in July for the month of June 2026. And considering that pay reporting requires quite sophisticated technical IT solutions, adjusting online payroll tech, so it is quite challenging for employers without having full information on how this reporting will be done. But as I mentioned, this will likely be done by the usual payroll using online forms of the Social Insurance Authority, but unfortunately they have not been made available yet. And this pay reporting will, from what we know, will include information on the employee's base salary, also variable pay separately, the employee's job grade. For now, verbally, we received information from the authorities that they will not limit in the reporting system the number of job grades or categories the employers can have. So it seems that we will have a rather flexible system, but you can never know. We will know for sure when we see the final draft laws of regulating the reporting. And the reporting will also include the employee's actual working time for that month. And once Social Insurance Authority receives this monthly information, it will then generate monthly and later annual pay reports and deliver it back to employers. And this is how employers will receive the information on each employee's average pay, monthly and annual, and also average pay in separate job categories and at the company, split by employee gender. So the employers themselves will not have to prepare separate reports. They will submit the data to Social Insurance Authority and it will do it for the employers, which is actually, I think, quite a big help. There is one exception, however, applicable to temporary employment agencies who are working under this specific regulation. So unlike the general process, these companies will have to prepare the reports themselves, but this is the only exception. But for now, there is still a lot of uncertainty about technical details on how this reporting will be done, and it primarily relates to various benefits which may be taxable or untaxable but still have some financial value. So this includes private pension contributions, also various stock options and similar incentives and other benefits. It is not entirely clear right now how and if and to what extent these will have to be reported, especially for those benefits who are not taxable and usually are not disclosed to the Social Insurance Authority. The second part of the providing the information is providing it to the employees. So Lithuanian draft law follows the regulation of the directive pretty closely on this. So employees will have the right to request information on their own and their job categories average pay data, either directly from the employer or do this anonymously through the Works Council or other employee representatives like a trade union, or through the State Labor Inspectorate or to the Equal Opportunity Authority. I'm sorry, I will not try to pronounce too many times ombudsperson because it's a nightmare for me. So the employees will have quite a lot of choice how to ask for this information. And the employers will have to provide this information to the employees within 1 month after it is requested. Now, the law also says that employers will have to provide information, the same information that is generated by the Social Insurance Authority. So they will have to provide that information, but if the employer wants, it can add voluntarily additional information, data, explanations if the company feels that the information generated by Social Insurance Authority leaves too many unanswered questions and it wants to preemptively address them without waiting for the employee request for clarification. And as Edgars mentioned, yes, the directive requires employers to remind employees about this right at least every year. So this is also repeated in Lithuanian law. And we do have some safeguards aimed at protecting confidentiality. So if there are too few people in this job category, or too few people of one gender in the job category, so the employees will not have the possibility to see this data themselves. However, the employer will have to provide this data either to the Works Council or to the mentioned authorities, who then will review the data and let the employee know whether there is a 5% or higher gender pay gap in the category or not. And if there is a 5% or higher pay gap in that category, then the employee representative body or the authorities will advise employee on the next steps. So, for example, a right to initiate an employment dispute at the Labor Dispute Committee, a right to ask the employer for additional information, and so on. But the employee themselves will not see the pay data of a very small group of employees where confidentiality may be breached. Now, about the gender pay gap reports that are required by the directive. So, as I mentioned, Lithuania does not move too far from the directive here. The headcount thresholds, the timing, the frequency, it is the same as provided in the directive. But as I mentioned, besides temporary employment agencies, the gender pay gap reports will be prepared not by employers, but by social insurance authority. And once the employer receives this report provided in the social insurance system, then it will have within 1 month to provide the report to the employee representatives and also to the employees if more than 2 employees in the job category of the same gender exist. So once again, if it's a very small category with too few people, then limited information on gender pay gap report will be provided to employees. And the Social Insurance Authority, the SODRA, will make some information on pay gap reports public. So the first one is this, I will call it simplified monthly pay gap report for companies with 8 or more employees, where there are at least 4 employees of the same gender. So it will not be split to job categories or anything like that. It's just average salary at that company for that month for male and female employees. And this information actually is already available on Social Insurance Authority's website, but it is quite general and does not provide the realistic information, for example, median pay gap at all time. And these directive-based gender pay gap reports, they will be published also on the Social Insurance Authority's website every year or every 3 years, depending on the headcount. And to finalize some other obligations applicable to employers as of June. So the pay transparency requirements in recruitment. So in Lithuania, we already have a requirement to provide the salary range in all job ads, regardless of where they are posted, whether it is LinkedIn, the company's website, or anything similar. The employers have this obligation, and there is an obligation to provide the candidate information on the financial terms of the collective bargaining agreements applicable at the company. But since we do not have many trade unions and collective bargaining agreements in Lithuania, this will be relevant to a limited number of companies. And as mentioned in the directive, employees will have the right to disclose their pay information with the purpose to ensure equal pay for the work of equal value. So the confidentiality terms of employment contracts and company policies will also have to be adjusted. And finally, some brief information on employer liability for breaching the rules related to the directive or pay quality. So even though the administrative penalties will likely be updated and increased, they're still too small, in my opinion, to make an impact. For example, it's up to 1,500 euros for a violation of pay transparency laws, and it is imposed not on the company, but on the company's managing director or another responsible person having the power to implement or adopt these documents. So this is really not severe financial risk. However, the primary financial risk comes from employment disputes, because employees can always file a claim in the Labor Dispute Committee, which is free of charge, very quick, no risk for the employee, or later in court. And financially, the biggest risk in Lithuania is having a dispute with someone who no longer works for the company. Because if the court decides that the company failed to fully settle with the employee, including failed to pay equal salary for the equal type of job compared to their colleagues, then besides the amount that was unpaid, the employee can claim their average pay for the entire time from employment termination until the case is fully resolved. So it may be 6 months, 1 year, 1.5 years, or 2 years if it goes to the Supreme Court. So the financial cost of liability is quite high, actually. And right now, this penalty is capped at 6 months, but the draft law has removed this cap entirely. So if I was an employer, this is what I would be mostly afraid of. And this is it for me. You can see my contacts here, but I believe my colleagues will share the slides and the contact details with you after the webinar. And move forward to Estonia, where my colleague Karl Oskar, who is our employment and tax expert at our Tallinn office, will talk to you about the situation in Estonia. Thank you.
Hi, good afternoon from Tallinn as well. As Agnietė so kindly introduced me, my name is Karl, and I'm an associate at Sorainen Estonia's employment and tax teams. And today I'll hopefully tell you something useful about Estonia's progress in adopting the Pay Transparency Directive, what we do know and what we don't know, and how to move on from there. So, as a starting point, going over the current status and what we have so far, the sad truth is that, as has been already mentioned during both the introductory remarks and by Agnietė, is that in Estonia we still do not have a draft law. According to public government action plans, this was supposed to be ready for November originally, and other reliable sources have given us the information that the draft law was in fact ready in October of last year, but then government plans changed slightly, and the new aim is to have the directive implemented in as minimal fashion as possible. And for that purpose, the ministry in charge of the matter ordered an additional analysis. But what this analysis has currently said about the directive's minimum requirements and how and if these have been introduced into a new draft law, that we unfortunately do not know. But this at least still does give us the small certainty that as long as there aren't any major hiccups in the legislative process in Estonia, the transposition of the directive will be as minimal as possible and will not impose any country-specific requirements, in addition to anything related to how exactly reporting in Estonia will be handled. And the ministry in charge of the matter that I mentioned, I have it brought out here as the Ministry of Economic Affairs and Communications, specifically because what they do have, and where most of our specific information comes from, is that they have a web page dedicated to pay transparency, which you can access, and it gives you so far mostly an overview of what the directive's general requirements are, but also it gives an overview of Estonian plans for how the state can help employers cope with the directive's requirements. Moving on to these state aid requirements, as I jokingly titled the slide. First of all, some of these promises are a bit more vague, such as that digital tools will be created to ease the administrative burden. Agnietė previously discussed in more detail about how reporting and calculations will be handled in Lithuania by certain public authorities. Whether this will mean something similar for Estonia, we unfortunately do not know. We only have these vague statements so far. Something a bit more specific is that for employers who use payroll software that can interface with Statistics Estonia's, that is the Estonian Statistics Authority's data exchange services, and where the employers also provide all the necessary information, such as about job categorization and which jobs are in the work of equal value and are therefore in the same category. If such information is all provided to Statistics Estonia via these services, then pay gap reports, which can be created automatically by Statistics Estonia. Now, of course, as these pay gap reports only apply to employers with 100+ employees, the truth is that this will apply to approximately only 900 organizations in Estonia, of which about 200 are government institutions and municipalities. So about 700 private employers will have to handle this part of the reporting of this part of the directive requirements. Furthermore, to help cope with the directive's implementation and coming to terms with all its requirements, the government is planning to organize trainings for employers throughout May to December 2026. And as part of this program, they also plan to come up with a web training, which presumably will then be available indefinitely. But something more specific that we already do have for Estonia, even though we don't have a draft law yet or anything specific like that, is that we do have an Excel tool available for helping with classifying jobs, assessing their value, and then categorizing them. This Excel tool and the guidelines accompanying it and helping understand how to use it, these are unfortunately available only in Estonian. Also, these things can also only be accessed in the Estonian version of the Ministry's webpage for pay transparency. Now, of course, if you're going to handle pay transparency more on a regional or global scale, then maybe this tool isn't all that useful for you. But still, I thought I'd show it off just for a moment, if in case you have plans to handle or if the directive's implementation, you have a need to handle also job categorization for Estonia specifically. As I said, it's only available in Estonia, but basically it allows you to easily split these different factors that go into assessing the job's value, skills, effort, responsibility, work conditions, and give them different weights. And these weights can be further subdivided into specific factors such as knowledge and skills. And based on how much value each job derives from each of these specific categories, it can be assigned a value of 1 to 6, which then as a multiplier of the category's value and the relative difficulty gives us a point score, which can add up to a maximum of 1,000. And then once you have assessed all different jobs across all the different categories, you can get a final score, which you can then more easily use to more easily compare the jobs for assessing their relative value of the work they do, and use these for categorizing the different jobs, and further for assessing how much different persons should then be paid. And of course, which jobs need to be reported. For which jobs the reporting needs to be handled together. But next to these completely new things, both from the directive and what we already had to help cope with its implementation, I'd also like to stop by for a moment in what we have in Estonian legislation so far. Now, one aspect, of course, is that the directive uses several terms which will require, the content of which will be determined at least partially by national law. So, for example, the important thing is that, at least according to the directive's explanatory notes, workers who fall under the directive's requirements in Estonia should basically be only employees with employment contracts. That is, not persons with service contracts under civil law, and not also corporate officers, as their jobs are also not covered by employment law in Estonia. Now, when it comes to workers' representatives and their role in pay transparency, then this will likely be more difficult in Estonia. First of all, this will of course cover both union and non-union representatives, but union membership in Estonia is generally very low. And also, while employees can always elect non-union representatives called trustees, then that is also quite rare. All organizations of a certain size need to have their employees elect a working environment representative, but as the name implies, their specialty is in occupational health and safety. So again, looking into the directive's explanatory notes and the recommendation to to pay attention to national specifics when it also comes to the role of workers' representatives, then I suspect that in many cases there won't be any relevant representatives to consult, for example. And finally, I just thought to quickly mention that while the directive also also talks about employers and certain criteria are set and certain requirements are set by number of employees at an employer, then I quickly mentioned that in Estonia, the legal definition of an employer is generally not problematic. All legal and natural persons can be employers. As to the more specific requirements that we already have under current Estonian law, then nothing similar to the Lithuanian pay policies or even any requirements to reveal salaries or salary ranges before employment starts. Nothing like this is necessary. However, what I would like to emphasize, just for clarity and for safety, is that equal treatment regardless of sex is already legally required. And also explicitly, this is also required in working life. And these requirements, of course, also extend to workers operating under all sorts of contractual arrangements. For example, also these natural person service providers working under service contracts and not employment contracts. So coming back to everything and summarizing what we know so far is that, again, we're still waiting for the Estonian draft law to see how exactly the directive will be transposed into Estonian law. And while the expectation is that, yes, this will be done to a minimal extent, we're still waiting to see what the ministry determines this minimal extent is. And of course, even if this is attempted, then there's always a chance that something comes up, either accidentally or on purpose during the legislative process, that changes these plans. But if you are interested in already getting a head start for June, then we have in Estonia a neat tool to help you evaluate the worth and value of different jobs. And of course, if you have any Estonia-specific questions or matters come up that otherwise require Estonia-specific employment advice, then you can feel free to contact me either now, or if you have any quick questions based on this limited information that I was able to provide for you today, then do feel free to use the Q&A function and we'll get back to you at the end of the webinar. Now that I've told you all we know about Estonia, I will hand over the reins of today's webinar back to my Latvian colleague Edgars.
Thank you, Karl-Oskar, for the informative presentation. Similar to what Karl-Oskar was presenting, we chose a similar agenda approach. I'm going to discuss the current status, what we know so far or we don't know, and also what are the implications from the current regulation. And if we talk about the current implementation status, then what we know is that the responsible ministry is the Ministry of Welfare. And as mentioned before, the draft law is in development, and a separate law is planned to implement the requirements of the directive. So this means that potentially the labor law might not be amended, but we will see. And yeah, the first draft is delayed, of course, because the Ministry of Welfare announced that the first draft might be ready before Christmas of last year. And I contacted the ministry at the start of February, and there was still no date estimate as to the first draft. And also, it is not quite clear which institution will be responsible for supervision once the directive is implemented. Most likely it will be the State Labor Inspectorate. However, this is not something that can be said for sure. But what we do know so far is that, or we might not know, but still, is that the Ministry of Welfare has announced in September that even though there are no criteria in Latvia or the first draft hasn't been published, the employers are still expected to initiate the employee categorization and evaluation process. And this is maybe because the ministry has plans to just impose the standard criteria, which means that the 4 criteria, effort, skills, responsibility, work, and work conditions would be something to base off of. And the idea is not to interfere with the employer's freedom of decision in this sense, so as not to create this bureaucratic obstacle, but just sticking to the basic requirements of the directive. And also the directive requests that the states provide analytical tools or methodologies to help employers assess the value of work. But currently there is no information for Latvia whether these analytical tools or methodologies will be presented in a timely manner. I hope that they will be presented eventually, but perhaps not with the implementation, but we have to see. But we know something about the reporting, is that it is not planned to apply this reporting obligation to employees who have less than 100, employers who have less than 100 employees. Also, there is some difficulty with gathering data because the state does not have the technical means to obtain the necessary data themselves. So it will be entrusted on the employers to provide this information. Having said that, at the start of February, there was still some discussions. Maybe the data of the state authorities may be used, but yeah, we just have to wait and see. For the time being, we know that the tax reporting system might be used as a tool where the information can be provided. And the Ministry of Welfare had potentially planned to introduce an electronic form, which will cover the data requirements set by the directive. And some guidelines will be developed to help employers fill in this form. That is what we know about the progress of that directive. But of course, we similar to Lithuanian colleagues and Estonian colleagues, we have something to work on in terms of the current national law. So the Article 60 of the labor law states this basically introduces the same principles of equal work and equal pay for the same work or work of equal value as the directive. And so this regulation has been in force for 20 plus years. So there should be some expected body of work or body of case law to work around accumulated in this period. But we also have semi-implemented some of the regulation in the national legislation already. So in 2018, new requirements regarding job ads were introduced. And also, as Carlos mentioned, the directive refers to definitions set in national law. For example, to interpret the definitions of workers representatives. And I will talk about this in more detail in the further slides. So if we discuss the disclosure of information pre-employment, so comparing the directive and the labor law of Latvia, we see that the directive requires the employees to provide information about the initial pay or its range, and also the job postings and job titles have to be gender neutral. So in this sense, it is similar in Latvia, whereby a job posting cannot apply only to men or women, and it should also include the monthly or yearly salary or the range of the salary or the hourly salary rate. But I guess the difference is with the directive that the directive sets the definition of pay a little more broader. So under the directive, pay means the salary as well as all the other considerations which the employer pays the employee in connection with work. So this would mean also the variable pay, any benefits. This would fall under the definition of pay. However, under the labor law of Latvia, only the base salary has to be provided in this job ads. So we can see that there's discrepancy there, well, even if the regulation seems to be sort of implemented, it may be subject to change, and this is something that we need to take into consideration. As to whom will the directive apply to, and Karl Oskar touched on this in terms of Estonia as well. But the question we have been asked by our clients is whether it would apply to board members, whether it would apply to royalty recipients or persons who have concluded an author agreement. So from the perspective of the Latvian labor law, these would not be considered employees. However, there might be contexts where the worker status may be applied. So, for example, in terms of social insurance, or there might be cases where the author agreements are requalified as employment agreements if they have these corresponding conditions. So this is something also to consider. Perhaps if you have this practice of concluding service agreements or author agreements, just to maybe assess this risk of requalification. And also, well, our guess for Latvia is that it is unlikely that the obligations of the directive will be applied to board members and royalty recipients. However, this is something to consider also in terms for other countries where there might be a different approach to defining what is a worker. And another definition, workers' representatives. So under the Latvian labor law, workers' representatives are defined as either trade unions or authorized representatives who have been elected in accordance with the requirements of labor law. So the conclusion would be that well, if the directive stipulates rights to workers' representatives, they have to be appointed in accordance with the labor law. This would pertain to situations where only workers' representatives have the rights to do something. For example, in the case of the joint pay assessment, the directive only stipulates the right to workers' representatives to participate in drafting this pay assessment. However, most obligations have been set in a broader sense. Most obligations allow either for workers' representatives, workers themselves, or other representatives chosen by the workers to be entitled to a certain right. So this is also something to take into consideration. As it pertains to the definition of an employer, the directive does not provide such a definition, so we do not have any other choice but to apply the national definition, which in Latvia, an employer is a natural legal person or the work placement service provider. And in this case, it begs the question, what if you just have a branch here in Latvia? A branch is not considered a separate legal entity. However, this is a bit of an unknown situation in terms of legal requirements, but usually the local law is applied to the contractual relationships for the employees in branches. Therefore, if this is the case, even if there is only a branch here, it would probably have to be treated as a separate employer because there would be rights arising from the specific Latvian labor law, perhaps for job ads, definitely for reporting obligations to the specific authority. There might be different criteria set in the national legislation as well. And as I mentioned, the legislation has already been somewhat introduced for a number of years, or rather the principles have been implemented for a number of years. And as an example, I've just here referenced a judgment of the Latvian courts in 2007, which mentions a principle that has been stated in the directive as well, which is that the previous employees could also fall into comparison. So here was stated that the man who has performed the same work might be compared to a different employee prior to the employment period. And also one thing to consider is that the European Court of Justice has admitted that the national courts only have the ability to assess whether work is of equal value and whether there is an objective justification for a pay difference. And to summarize for Latvia, yes, the implementation is delayed, but the employers are nevertheless expected to proceed with the work evaluation and categorization. And the national legal teams will still be prevalent, considering that the national definitions are used in the context of that directive. Also, each country will have specific requirements in terms of exemptions, maybe some communication specifics, and as I mentioned, reporting, because the state authorities will be different. And also the idea that only national court can evaluate whether work of similar value or work of equal value is performed. This is something also crucial, and since there are different courts here, then there might be different interpretations as well. So our advice would be, in case you are implementing these equal pay processes in a centralized manner, then we would advise to then have an individual country-specific adjustments made for each specific country. Yeah, and of course, if you have any questions, feel free to reach out. And with that, I think we can proceed with the Q&A portion. We received, I think, an excellent question before the webinar, and I think it would be nice to start to kick off the Q&A session with this. Is that somebody asked, in case of standardized job classifications from compensation surveys. So there are compensation surveys which reflect typical market values of positions. Can these be used instead of the employer's own job evaluations? And would this serve as evidence of compliance? So in my opinion, you can use these market values as a reference point. However, it should not be used, so to say, one-to-one in your company, because the value of work has to be estimated in the specific context of the organization, right? So, so the standardized work classifications just consider the typical market value, but they don't consider the specifics of the company. Just to mention an example, you might have the standardized value of accountants and lawyers be the same, right? But if you are an accounting firm, then this changes things, because in the sense that the accountant would be core to the business, right? Because the accountant would be generating revenue, delivering the services, and the lawyer, in this sense, although would perform an important function, might be an in-house position, so a support or a compliance function. So you can see that in these cases, the work value might not be the same because the context of the organization is different. So I would not advise using these predetermined values as your own, but you can have them for reference purposes, I would say. And I haven't had time to catch up with the Q&A questions, but I think that some might have been answered during my presentation, because I remember there's a question, by Cynthia. If there is a group remuneration policy set in place for a pan-Baltic company, should there be a separate Lithuanian remuneration policy, or common policy across the whole group is sufficient to be compliant? I guess I can answer this because it was in my presentation also, that you should probably, well, you can have a centralized policy. However, it does not mean that you will be compliant with the local legislation. So you would need probably to adopt this, well, not probably, most definitely, you would need to adopt this for each specific country. And well, this is, Agnietė.
Thanks, Edgar. So I can supplement for Lithuania, at least, because as you saw in Lithuanian presentation, Lithuania has quite extensive content requirements for what must be provided in these pay policies. So working with international clients, these group level policies are usually very good general information, but 90% of the cases, they need some local addendum or appendix to add the information that is required by Lithuanian law. So this is usually the case with group level policies, but they do some parts of the work, and it means that you don't need to work from scratch for each country because some information will be similar. So yeah, partially can be used with some top-ups from local lawyers or HR staff.
Thank you, Agnietė. Yeah, I agree. And also, I think this kind of answers a question from Aline, which is similar, if I'm not mistaken. And then there's another question from Cynthia. I think this is more in terms of the Lithuanian specific requirements. Do I understand correctly that the EU Pay Transparency Directive does not require employers to publish all salary ranges, but only ensures that the individuals can access information about their salary level and the relevant pay range? If that is correct, does it mean that the Lithuanian government has decided to go beyond the directive by requiring that all job categories and their salary ranges be available to all employees and included in the remuneration policy? So I can at least answer the first part of the question, and maybe, I don't know, Agnietė, can you maybe cover the second part? Because, well, the directive does not require employers to publish all salary ranges. Only the employee, only in the employee can receive information about the individual group in which the employee has been kind of set in, right? So you do not have to publish all salary ranges, but only provide access to the specific employee regarding their specific work value. And I don't know if this is something that the Lithuanians have went beyond.
Yes, Lithuanians are, in my opinion, overly enthusiastic with implementing employment-related EU directives. So this is not an exception. And yes, the job categories and pay ranges are a part of this remuneration policy. And the law says that it must be made available to all employees. So how the State Labor Inspectorate sees it is that all employees should be able to see not individual employee salaries, but the range for each job category, even if I'm not in that job category. So this is how Lithuanian authorities interpret our legal requirements, and I don't suspect this will change in the future. And then it's up to the company to decide like how important it is to be fully compliant, or whether they are comfortable with taking some level of risk. Because in my opinion, maybe I'm a bit too brave here, but the legal risk of limiting, let's say, pay ranges of completely unrelated job categories should not be very high, because it does not really affect the pay quality of the employees working in the same category. But the labor authorities of Lithuania would disagree with me here, probably.
Being cautious of time, I think we have some left, maybe one or two more questions. and somebody has asked, can the categories of employees be internal, or should they be public for everyone to be assessed? If the titles are kept all the same, as an example. So the categories of employees can be kept internal. What we are talking about basically is the criteria by which the worker value has been set. So there might be exemption for employers who have less than 50 employees, but if not, then these criteria, the skills, effort, work conditions, how this is used in the company would have to be made, well, not public, but made available to the employees. And also, employers are allowed to kind of stipulate that this information is nevertheless confidential, because it might entail commercially sensitive information. But yeah, categories can be kept internal. So maybe Carl Oskar, a question for you regarding the job evaluation in Estonia. Is the job evaluation framework in Estonia that was showed, is it expected to be implemented as the main evaluation criteria for defining job categories, or other internal evaluation methods for categories are expected to also be accepted?
So for clarity, this is a tool prepared as part of a government project to help employers. It currently isn't legally binding, and it is highly unlikely that exactly this categorization and this tool will become mandatory to use. Based on the currently planned approach of implementing the directive to its minimal extent, it is highly likely that basically any categorization or evaluation system that meets the directive's requirements will be suitable to use in Estonia. So no need to worry ahead of time that you also need to do a separate categorization in Estonia based on this tool if you want to handle meeting the directive's requirements as regionally or group-wide as possible.
Yeah, and to add what Carl Oskar was saying, multiple EU countries have this approach where they have some sort of methodology or some sort of description of how the criteria are used, should be used, but it does not mean that you can you have to just use what is said. You can choose the criteria by yourself and set as much as you want, because you need to reflect the work value within the context of your company. So the legislators will never be able to provide an exhaustive list of criteria for you to use. So yeah, I guess feel free to be creative and use what you deem fit. Perhaps the last question, I apologize for the question that I did not read out, but maybe we have some sort of way to communicate them afterwards. Is it correct that the directive indirectly implies that all companies across the EU will now have to have formal employee representatives? Not necessarily. Of course, there are, as I mentioned, obligations which only the employee representatives can invoke. So, for example, the joint pay assessment. But if there are no employee representatives, then it just means that either the employers or other representatives which have not been elected in accordance with the labor law should be well, they can be representing the workers even if they have not been elected. So there are a lot of obligations for workers and other representatives. Yeah, so not just workers representatives. Of course, we can help you with legal assistance in job mapping or establishing the value of work. Of course, all the employment documentation, as I'm sure there will be challenges, and and especially if it comes to comparison in between the Baltic states. And also, yeah, the communication with the employees, whether it's internal, whether it's a dispute or consultations with representatives. Of course, this is all something that we can help with, and please feel free to reach out to us if you need our assistance. But for today, I think that's all for today. Thank you for being present, and we'll see you next time.